This video summarizes objectives 11 and 12. Objective number 11 is to list and define the stages in a criminal trial. Objective number 12 is to explain the different roles of judges in adversarial and inquisitorial trial systems. As noted previously, most criminal cases are disposed of before trial. The few that reach this stage are either decided in a jury trial or a bench trial. Our focus in this section will be the jury trial. One of the defining features of the U.S. criminal justice system is the right to a trial by a jury of one's peers. Whether a trial involves a jury or not, its main purpose is to determine the truth, specifically whether the defendant is guilty or innocent of the charges brought against them. This search for truth takes place within an adversarial system governed by strict procedures and rules. In a criminal trial, the two opposing sides are the state, represented by the prosecutor, and the defendant, typically represented by a defense attorney. The prosecution carries the burden of proof and must demonstrate the defendant's guilt beyond a reasonable doubt. In contrast, the defense works to undermine the prosecution's case and raise reasonable doubt about the defendant's guilt. Ultimately, it is the role of the jury in a jury trial or the judge in a bench trial to evaluate the evidence presented and decide whether the defendant is guilty. The following are the principal purposes of a trial by jury: to protect citizens against arbitrary law enforcement, to prevent government oppression, to protect citizens from overzealous or corrupt prosecutors, and from eccentric or biased judges. In many jurisdictions, jury pools are drawn from voter registration lists. However, because many eligible citizens do not register to vote, some areas now use multiple sources to compile a more comprehensive list of potential jurors. For example, Kentucky selects jurors from tax records, voter registration rolls, and driver's license records of individuals age 18 and older. From this master list of eligible jurors, a random selection is made to create the jury pool, also known as the veneer. Not everyone chosen for the veneer will ultimately be qualified to serve. States differ in how they compensate citizens for jury duty. Next, up to 30 individuals from the veneer are randomly chosen to form the jury panel, the group from which the actual jury is selected. To ensure impartiality, these individuals undergo a screening process called voir dire, during which those with potential biases or an inability to fairly evaluate the case are identified and removed. Voir dire, meaning to speak the truth, allows the judge, prosecutor, and defense attorney to question prospective jurors about their backgrounds, beliefs, and any knowledge they may have of the case or the defendant. If there is reason to believe a juror cannot be fair and impartial, either side may challenge the juror for cause and request their removal. In addition to challenges for cause, both the defense and prosecution may use peremptory challenges to dismiss jurors without providing a reason. However, these challenges may not be used to exclude jurors based solely on race. The number of peremptory challenges allowed is limited by state law. Once the jury is selected, the trial begins. In general, the stages of a criminal trial include opening statements by the prosecution and defense, prosecutor's case, presentation of evidence, defendant's case, government's rebuttal case, closing arguments, jury instructions, deliberations, verdict. To find a defendant guilty as charged, the jury must be convinced beyond a reasonable doubt that the defendant has committed the crime. If after serious deliberation, a jury cannot agree on a verdict, the result is a hung jury. Judges have special instructions for deadlocked juries. They are called Allen charges because the U.S. Supreme Court created them in 1896 in the case of Allen v. United States. If a jury remains deadlocked, the judge declares a mistrial, and the prosecutor must decide whether to retry the case. Professor Reese provides a link to a pamphlet called You the Jury. This pamphlet provides additional information specifically related to trials in Kentucky. Around the world, there are two main types of trial systems. The first is the adversarial system, which is used in the United States except in Louisiana. In this system, the truth is pursued through a kind of legal contest between the prosecution and the defense, each presenting their case to a neutral judge or jury. The second is the inquisitorial system, which takes a different approach. Instead of a courtroom battle between two sides, the inquisitorial system relies on a thorough investigation, where a judge plays a more active role in examining the evidence and questioning witnesses. Although these systems are distinct in theory, most countries include features of both. Regardless of the system, all defendants are entitled to a fair trial and are protected from being forced to testify against themselves. Once again, Professor Rees stresses the need to read your book carefully to fully understand the court process. Have a great day.